There's going to be some formal kickoff. Okay.
Good evening, everyone. I'm Tessa Davidson, water rates attorney, and
Good evening. My name is Mike Hammond. We're both Corrales Seños, and I as a 40-year public sector water manager and water developer, have a small farm here in Corrales as well. And I just retired as the New Mexico State Engineer in July.
I guess, Melanie, we're just starting. So I'm going to start the presentation tonight. But before I did, and let me just give you a little introduction. I've been doing water law for 30 years. Fourth generation New Mexican from Catron County. My family homesteaded there, ranch and farm all up and down the Middle Valley. I was one of the first to go to college in my family. We have a very rural family background, and was fortunate enough to be able to go to law school and do water rights work, almost primarily since the time I started practicing law. And before that, I worked, my first engagement was with the MRGCD, the Middle Rio Grande Conservancy District, doing research on the Bosque Task Force before I went to law school. So I had some grassroots experience working with the district, and then worked for the law firm that represented the MRGCD before Mike was chief engineer there. But since then, I do a lot of ag work. I represent New Mexico pecan growers. They have about 35 to 40,000 acres of irrigated pecans in the Lower Rio Grande. Farmers all up and down the valley, and private clients. So really my work's more on the private side. And Mike and I were just involved in the Texas v. New Mexico Supreme Court case. Mike as the state engineer and witness. I'm a lawyer for New Mexico pecan growers who's amici in that case. And we've been working with the New Mexico defense team for New Mexico and the U.S. Supreme Court. So unfortunately, the case is still pending. It's going on its 12th year. It's crazy. And we'll see what happens this next year. We'll either settle or go to trial for sure. That's all I can say. But before I start, I like to start off with just a quick little water quiz. And I'm not going to ask you to answer out loud, just answer in your head. It's true, false. And this kind of sets the stage for what everybody thinks they know about water rights in New Mexico. And these are all questions in New Mexico. So first, true or false? Using water for drinking purposes is considered the highest and best use for water, and it's given priority over all other water uses in New Mexico. True or false? Well, if you answered true, you were wrong. We don't give priorities of uses, types of beneficial uses in New Mexico. All uses are equal under the law. So using water to wash cars in a car wash has the same level of importance as you using water to drink, to live. So in New Mexico, we don't give a hierarchy of priority in the beneficial use. Okay, true or false? The owner of a piece of property in New Mexico does not own the water that is in a stream or pond located on the property. If you answer true, you were right. Just because you own a piece of property doesn't mean you own the water that's within that property. You may have established a legal right to use water that's on that property, but you have to establish it pursuant to law. And all wet water, we talk about wet water and paper water, which is really weird as water administrators and water rights lawyers. All wet water, the actual water corpus itself, is owned by the state of New Mexico. The public owns all wet water. If you have a right to use water, you have a legal right to just use it. And just because it's on your property doesn't mean that you have any right to use that water. You have to have developed the right to use it in accordance with the law. Okay. Same thing for water under your property. You don't own any water under your property. In Texas, if you capture it, you own it. But here in New Mexico, that's not necessarily the case. You have to develop a right to use water under your property. Okay, so let's say you have a legal enforceable right. You've established a right to use water. Does that mean that you're guaranteed to always be able to use water in New Mexico? True or false? Well, I guess that's not a true or false. I asked that kind of open-ended. Even if you establish a legal right to use water, that doesn't necessarily ensure you get to use water. First, you could have a legal right to use water and no water's there to use. And that's something that we're facing all across New Mexico, right? You could have the oldest water right that you've established and you've owned forever. And if there's no water in that stream, sorry, there's no way to use it. Also, if you established a right to use water that was later in time and it has a junior use, a junior date, priority date, and I'll get into this in my presentation, in times of shortage, you can be told to shut off your water use so that the senior who has an older right gets to use all their water first. And that's the priority system in New Mexico. So just having a legal enforceable right doesn't guarantee you get to use water in New Mexico. And finally, the right to use water on a piece of land automatically passes from the seller to the buyer of the land through a land deed. True or false? Depends. It's a trick question. If the water right was established for irrigation purposes, and you buy that land with a water right used for irrigation purposes and your deed is silent, yes, you get the water right by operation of law because it's legally appurtenant to the land. It's kind of like buying a piece of property where you have a legal description and there's a house on it, right? Your house is a legal an appurtenance. And your deed doesn't say with the house, it's 2,800 square feet. It just describes the real property and you get all the legal appurtenances. Under the law, irrigation water rights are considered legally appurtenant to the land. So if you get a piece of land with a vested water right and the deed's silent, you get the water right. That's what the law presumes. Now, meaning there's no reference to water rights. It's just a piece of land. Here, I'm going to give you tract 18 on MRGCD map 36. You get the house, you get the water rights. If there's water rights there, you get all the stuff that's legally appurtenant to that tract in a deed, even if it's not described. So you can reserve water rights if you're the seller. If you're the seller, you can say, I'm going to give you this property, but I'm going to reserve the water rights. And you can sever those water rights by title. And then you need to go do something with the state engineer to move them. But you can sever water rights from the bundle of sticks that you get when you buy a piece of land. And very importantly, the law in New Mexico is very clear that the only water rights that go with a piece of land in a silent deed that doesn't reference water rights are irrigation water rights. The law does not say you get domestic water rights, commercial water rights, industrial water rights. And think of how many pieces of property have passed in Corrales that don't say with the domestic water rights in the well. There's a lot of deeds that don't say anything about your domestic water rights. We presume domestic uses go with the land, but there is no case saying that under the law in New Mexico. It's kind of a mess. That one issue's a mess. The best way to deal with any real property transactions, buying and selling, is address your water rights in the deed. Address them. If you're buying a piece of real property, make sure that the person selling you says with all water rights. And if you want to retain any water rights, make sure you're saying, I'm reserving my water rights from the sale. Yep.
So do they also have to go to the state engineer to register the water right as well?
There are statutes that require change of ownership filings, which are notice filings,
Okay.
but they don't have the legal effect of conveying water rights, but they are notice filings. Yeah. And I need to say real quick, I am a lawyer, but I'm not giving anybody legal advice because everybody has very unique situations. My purpose here today is to provide a nuts and bolts educational tutorial on where to start and to give you some background information on what possibly could apply to your situation. But I need to say that because everybody has very unique, specific facts that apply to their particular water rights, just by nature of when they were first used and what kind of water rights they are. So I did this, sorry,
I'm
Mike.
glad you brought that up
Mhm.
because I'm the former state engineer and can't speak for the agency formally tonight either. So
And I gave this presentation, I was looking in 2016 to the village council. So it's been 10 years. And was hoping that I would provide some nuts and bolts to prevent some things that I saw happening in our village that make us very vulnerable in a water rights way. So that's what I want to do tonight. I'm really happy you're here. I'm happy that people are interested in being educated because I think there's a lot of stuff we could do to help each other and help the village. So, Melanie, can you put up my PowerPoint? So next slide, please. So here's some New Mexico water rate basics. And I did kind of allude to some of this in our quiz discussion. But first of all, New Mexico follows the prior appropriation doctrine. And essentially what that means is the first person to use water and establishes a right to use it has a first in time, first in right. They have a better right. We call those folks senior water users, and they have a better right to use water over junior users. So under the law, a strict application of the prior appropriation doctrine, seniors get 100% of their water fulfilled before juniors get their water fulfilled. And that's the strict application of priority administration in New Mexico. It's very harsh. You can imagine, right? Let's say that car wash has a senior water right and your drinking water supply is junior. Under the law, they can enforce washing cars over your ability to drink water if it's a strict application of priority. Now, New Mexico finds a lot of ways and users find a lot of ways to get around strict enforcement. We have shortage sharing agreements and other things. And the state engineer's office never really shuts people off from drinking water, but there may be payback requirements or other things under the law. So as a health and safety matter, usually doesn't happen, but it could under a strict application of the law. I already explained that water is just a water right is just the right to use water. We call that a use effectory right. It's a right to use something. And when we talk about water rights, beneficial use or the use of water is a very, very, very important aspect of a water right. How much you've used in the past, when you use that water, what amount you used, and I already said when, amount, place of use, and purpose of use, all of the use elements define your water right. And all of that deals with how water is used, when it's used, and how much it's used. And so when you establish a priority date, that priority date attaches to when water was first used. And you can imagine all of the different priority dates of different water rights that exist in the village of Corrales. I mean, you can kind of just go through thinking about all the different uses and even new uses, new subdivisions, new homes. And we would consider those junior uses, more recent uses, and having junior priority dates for those wells in all of these new homes. The other really important aspect about the use, the water right use, is you have to use water to preserve your right to continue using water, meaning you have to keep using it to protect the right to use it in the future. You're not allowed to hoard a legal right to use water in New Mexico. And that's because we are a water short state. And under the prior appropriation doctrine, there's a thing called maximum utilization. And that means, let's just say, Sarah, you have a water right and you've decided, I don't want to irrigate my 3 acres anymore because it's a pain, right? There's weeds and other things, but I want to hold on to that until my kids are in their 30s and they may want to do that. You're not allowed to do that because the law assumes that your neighbor needs that water. And if you're not going to use it, you don't get to keep using it. You don't get to hoard it. The law assumes that if you're not going to use it, it reverts back to the public, and somebody who can put it to use today gets to use it. That's what the law assumes. So let's say you establish a water right and you want to keep that water right, you have to keep using it. You are encouraged to keep using it. There's not a lot of incentive for conservation. You're not allowed to waste under the law, but there's not a lot of incentives except for conservation plans or water banks that the law allows, but you're not allowed to not use your water right and if you don't, you risk losing it. And there's 2 doctrines, forfeiture and abandonment. Let's say you have a property that had irrigation on it in the 1920s, established water right. And for some reason, let's say over a period of 3 decades since then, 30s, 40s, and 50s, the family that lived on that property just couldn't put the water to beneficial use. They didn't want to. They didn't think much about using water. You buy it in the 70s, years later, and you go to investigate whether or not there's a valid water right on that property. Well, there's a doctrine called forfeiture, and the law says 4 years of continuous non-use prior to 1965, that's an important date, prior to 1965, operates as an automatic forfeiture of a water right. And you think, well, who's going to know? Well, the state engineer in the state and Google Earth and aerial photography shows evidence of non-use. And so that's something that can happen. You may even resurrect that water right today and you think, I'm using water today. If you ever go to do something with that water right, the state engineer may look at it and go, oops, the priority was abandoned, or I'm sorry, forfeited, 4 years continuous non-use, and you don't really have what you think you have. So just FYI, establishing a water right, good, but you have to continue using it and have continuous proof of using it to keep it valid today. The other doctrine is abandonment, and that's just common law abandonment. You can abandon any property right with intent to abandon. A good example of abandonment that we see a lot are building houses on irrigated property. You've essentially put a house on property that was irrigated, and you can't irrigate it any longer, and you're not irrigating it, and the state would consider that evidence of intent to abandon, unless you did something else with that water right. You could move that water right and preserve it, but if you leave it there, years of non-use, there'll be a presumption of abandonment. Okay, next. So what are the, actually, I think we're back a little bit. There we go. MRG on this slide represents Middle Rio Grande Valley. And the types of senior uses that we have in the Middle Rio Grande Valley are first, the most senior, the middle 6 pueblos. Under the law, we consider those uses as time immemorial or Aboriginal priority dates. Then we have the Spanish land grantees that came most of the time after the middle 6 pueblos were in their current locations. We have homestead patentees. Those are folks that were able to homestead and get patents from the U.S. government, and those are in areas outside of land grants. The land grants don't have patents because Bureau of Land Management never went through and surveyed those areas, and they passed through land grant transactions. But essentially, your old senior uses in the Middle Valley are irrigators on acequias and community ditches. And New Mexico first began regulating water use in 1907 by enacting the 1907 Water Code. And this code created a method by which the state could start administering and regulating water use and water rights in the state of New Mexico. So when we speak of senior water rights, we generally, this is very general, but we generally are referring to surface water rights that were established prior to 1907. And you guys probably all know this. People talk about 1907 water rights or pre-1907 water rights all the time as being the ones that have value in the Middle Rio Grande and the ones that are senior priority date in the Middle Rio Grande. But even before 1907, you have this other layer of more senior uses. Pre-1907s were originally outside the jurisdiction of the state engineer. But after 1907, if you wanted to use surface water, you needed to acquire a permit from the state engineer to use that. And when you first put that water to use would establish your priority date for that use. We generally refer to those as junior surface water rights. Let's see, next one. So in the Middle Rio Grande, the junior types of users that we have really first start when we talk about junior with those new uses that first came into use after the construction of the Middle Rio Grande project. And the history on why the project was constructed really started in the 1890s with the railroad construction along the Middle Rio Grande Valley, and also these big floods that would come down the Rio Grande River and just wipe out communities, whole communities in the Middle Rio Grande. Those two things had an effect on old acequias, old pueblo ditches, and a lot of the old conveyance systems, washing them out, causing drainage problems, and the railroad bisected old community irrigation systems. So those two things really caused a problem in the valley. And the federal government came in and started looking at what's the feasibility of putting in a drainage project? MRGCD doesn't only provide irrigation water, it provides very, very important drainage benefits to this whole valley. I think someone told me once that Old Town used to have a drainage problem, and Nob Hill was the only thing that didn't, it went that far up in Albuquerque. So there was an assessment and a bunch of appraisals, and they came through and they decided to form the Middle Rio Grande Conservancy District and construct the project, drains and irrigation systems throughout this area. MRGCD runs from Santa Fe or Cochiti down to Elephant Butte Reservoir. It's 160 or 180 river miles of conveyance systems and drains. And as a result of the construction of the project, a bunch of new lands were now capable of being irrigated. They hadn't been irrigated before with these old acequias and community ditches. And in order to get the right to irrigate those lands, the MRGCD had to acquire a permit from the state engineer that gave it the right to deliver water to pre-1907 users, but also brand new lands under the MRGCD's permit. So when we talk about irrigation water rights in the Middle Valley, we talk about rights irrigated pre-1907 and rights irrigated under the MRGCD's permit. And that permit was issued in the 30s. So if you are using MRGCD facilities to irrigate, you may have a pre-1907 water right, or you may be irrigating under the MRGCD's permit. And if you sold your water rights off the property, you may only be able to irrigate if you have a water bank contract with the MRGCD. So those are the different types of irrigation that occur in the Middle Rio Grande off the ditches within the Middle Rio Grande Conservancy District. Then we over time, surface water supplies can supply all the demands of this area. So people turn to groundwater. And groundwater development really started happening in the maybe late 30s. Really just a few big groundwater wells were starting to be drilled by municipal providers and others. And so the state enacted a statute to take jurisdiction over groundwater development. Up until the 30s, everyone across the state of New Mexico could go and put a well in and use groundwater. In the 30s, the state said, state engineer, we're going to give you jurisdiction in those areas that you want jurisdiction, in those areas where you say, I'm declaring I want to control the water use. And so the state engineer had the authority to declare jurisdiction over groundwater in the state at different times. And in this area, the state engineer declared jurisdiction in 1956. So in 1956, anybody who wanted to drill a groundwater well needed a permit from the state engineer. Up until that time, you didn't need a permit. And we call those pre-basin groundwater rights, pre-56 groundwater rights. And after 56, they're post-permitted groundwater rights. And in general, we consider those junior uses in the Middle Valley. Also in the 50s, the legislature passed what we call the domestic well statute. That's 72-12-1. That allowed for automatic permits for indoor uses and for irrigation up to 1 acre of non-commercial land. Basically subsistent irrigation or landscape irrigation. The domestic well statute's been amended and it's been subparted many times. The same kind of process applies for livestock wells. And at one point, the state engineer's practice was to allow up to 3 acre-feet with a domestic well. That's automatically permitted, but more recently limits those to 1 acre-feet in the Middle Valley. So that was generally the Middle Rio Grande, but this is the type of water rights we see in Corrales in order of seniority. So in Corrales, we have pre-1907 surface water rights for irrigation purposes. I will say that because we're within a land grant area, sometimes proving up pre-1907 use is harder in this area than it is in other areas that have old homestead documents and proof of irrigation to get a patent. So it's difficult. It's more difficult in this area. And that is one area of my practice. I have a specialty in proving up historic irrigation water rights. Unfortunately, because we're in a land grant, it can be a little harder than it is in other areas in the Middle Valley. The primary documents to look and see whether or not a land has pre-1907 water rights is what's called the 1917 Drainage Survey. And that was done by the government before constructing the Middle Rio Grande project because they wanted to see what do we need to do to drain this area. Unfortunately, the state takes a designation of alkali on that survey as evidence of no irrigation. And I usually am hired to say, no, alkali says it's just bad drainage. That doesn't mean it wasn't irrigated. But it's really hard in this area to find other evidence of irrigation. So just want to let you guys know that. If you're interested in knowing what the state thinks about your land and the priority of when water was first used on your land, they will do a priority analysis for you. If you walk in the door and say, here's my legal description, tell me what you think. Now, what the state engineer thinks may not be the end of the inquiry, but if you're interested in what the state engineer would think, they usually will sit down with you and help you do a priority analysis on your land. Second level of priority, surface irrigations under the MRGCD permit. And then I referenced the pre-basin groundwater rights. Water rights that were used from wells drilled prior to 1956 for any use, domestic, livestock, or irrigation uses, and then permitted post-56 water rights for groundwater use. So these are the general categories of how water rights kind of split up in Corrales. The interesting thing is, until recently, for many, many years, the state engineer did not consider domestic well permits under 72-12-1 to really give you a water right. The state engineer considered that a permissive water use that you were just permitted to use. There was a case that went to the Supreme Court, New Mexico Supreme Court, the Bounds case, where the court said, well, they were challenging the constitutionality of the domestic well statute, some users were. And the court said, no, the automatic granting of a permit is constitutional. That's fine. The legislature could give that automatic grant of a permit. And you can just administer those water rights like you do everything else because they have priority dates. And I think it was a little bit of a backlash effect to that case because I don't think the state engineer really wanted a court to say that those water rights were subject to priority administration. But that's where that is right now. So not really included in this list are domestic wells drilled under 72-12-1, but we do know we have a lot of them. They're either going to be treated as a permissive use that the state engineer can assert that they can regulate and tell you how much you get to use at any given time, or they may be considered by the law to be a water right that's subject to priority administration. And I know that's clear as mud, but that's the way we look at it. I think personally they're water rights and they're subject to priority administration. Okay. Oh, I wanted to say one other thing, and you don't need to go back on the slide, but also it's really important to understand that once a water right is legally invested and you have an established legal water right, the law allows you to file an application with the state engineer's office to change that water right. So let's say you're going to build a house in Corrales and you want to build a house on half an acre on a 2-acre lot, but you're going to put a house on pre-1907 irrigated lands and you don't want to abandon that water right. So you can file an application with the state engineer to change the place of use of that water right or purpose of use, or you can sell it to somebody who wants to transfer it to a well so they can use it. The important thing is you do something to preserve that water right. If you just leave it there, you're going to be found to have abandoned it. So all water rights that are, with the exception of domestic well water rights, all water rights other than MRGCD water rights and domestic well water rights are subject to transfer and change in place of use or purpose of use. Does anyone have questions about that? I know I just got a little confusing. MRGCD rights are not considered to be private property rights. They're considered to be property of the MRGCD, which I also think is subject to legal challenge, but I'll probably retire before that happens. But currently, MRGCD permitted rights, you do not have a private property right. That's the way MRGCD views that issue. But your pre-1907s, your pre-56, and your state engineer permitted water rights, other than domestic well permits, are subject to transfer and sale and move around. Okay. All right. So with that description, you're probably wondering, well, how do we know who owns what in the Middle Rio Grande Valley? And I don't even know what I own. I may have a piece of paper, or I may have what the seller gave me, but how do we know what everybody owns? That's a good question. The Middle Rio Grande Valley is not what we call adjudicated. There is no water rights court decree defining everybody's water rights. The 1907 Water Code that I referred to earlier directed the state to adjudicate the water rights in all stream systems in the state, but they never got around to adjudicating the Middle Valley. That's because of a number of reasons, and I'll get into that in the next slide. But adjudication court decrees are supposed to define the owner, the priority date, amount, purpose of use, and place of use. And the code also allows individual users to file sworn declarations of their water rights claim with the state engineer. The declaration process was really to give notice to the world that I declare I own this water right. I declare this amount, this place of use, and this priority date. And in basins that haven't been adjudicated and there's no certainty, really the only thing that's available is either a declaration or whether or not you can show proof of a permit from the state engineer. It's really important to realize this as well. The declaration opportunity in the law is not required. So you can have a legally vested water right that you put to use, used it all these decades, continue to use it. It is as valid of a water right as somebody who went and declared their water right. There is no legal requirement that you are of record. You will be made to be of record if you try and change that water right. So if you have an original water right on land that's been used over 100 years and you never did anything different, no legal requirement to declare your water right. It's as legally valid under the law as one that is declared. You go to change it, the state's going to require that you declare it. And the state's going to look at it and give their opinion about whether they think it's valid or not. So really important. I think people do get confused if there's no declaration. It has no legal effect on whether your water right's valid. Okay. So despite the early directive in 1907 and almost 120 years later, this is a map of the completed adjudications in New Mexico in areas where we actually have court decrees that list out who owns what and where they can use and how much they can use. And this is the map of pending adjudications and completed adjudications. And if you see, the red is completed. That's what we saw on the prior map. The green are pending areas, and you'll notice the big white area where we are. So that's that whole Middle Valley where we have the highest population, the most uses, markets that people want to transfer and buy and sell water rights and protect their water rights. But we also have something that's prevented the adjudication, the Middle Six Pueblos. The state and other users have been very, is this accurate to say, Mike, afraid to quantify Pueblo water rights, to recognize I'm saying historically, this is not the case today, but historically to recognize and quantify Pueblo water claims because they're Aboriginal claims and they're time immemorial and they're the most senior. And I think there's been a lot of incentive not to adjudicate the Middle Valley for that purpose, but we still have an active water market. We still buy and sell water rights. We hire people like me to help prove up water rights, and people still can get determinations from the state engineer on whether or not a water right is movable and valid. So next slide. So historically, in the absence of an adjudication decree that sets forth priority dates and other elements, the state engineer's not really been active in enforcing water rights priorities in the Middle Rio Grande Valley. Priority determinations are made when transactions are done, but the state engineer has not entered an order saying your juniors shut off because seniors need water. And instead, we've all kind of shared shortages. In the Middle Rio Grande, in the Middle Rio Grande Conservancy District area, the districts had a policy of giving all users same access to water, and the MRGCD does not make a distinction of pre-1907s versus MRGCD rights. There's been a couple of lawsuits to try and make the MRGCD do that, but they've failed. They've been dismissed, not because the court dismissed them, but people lost gas. But that issue has not been actively enforced in the courts. So this has caused some friction, lack of enforcement of priority over the years. And as I said, one reason is the fear of quantifying the Pueblo's claims. But that's changing. And I'll get to that in the next slide. But another thing that's happened is the state engineer was given the power in 2003 to administer priorities in the absence of an adjudication decree. And that is called, we call it the 2003 AWRM statute. It's Active Water Resource Management Statute. And if I can go to the next slide, Melanie. That statute's found at 7229.1. And the legislature said because the adjudication process is slow and we have interstate compacts that we have to basically adhere to, the state engineer can administer priorities so not to interfere with adjudications, create impairment of rights, and create increased depletions. This statute was challenged and went all the way up to the New Mexico Supreme Court, and the court found it constitutional. And the way the state engineer's AWRM statute works, Melanie, is the state engineers to promulgate regulations for how to determine water rights and their priorities in certain basins. The state engineer has promulgated general active water resource management regulations and some specific regulations for specific basins, but has not yet promulgated regulations for the Middle Rio Grande Valley. Generally, what the state engineer is allowed to do is he's allowed to go through and determine a water right and use a hierarchy of evidence on whether or not that water right is valid. It starts with whether or not there's a court decree, like in a pending adjudication, whether or not there's a state engineer license, whether there's a state engineer permit. And then the last level is the best evidence available. And this is where your declarations become important. If the state engineer were to go through and start determining water rights for priority administration in the Middle Valley, that might be a reason you'd want to file a declaration because you have your claims of record. The danger of filing a declaration, and I don't want this presentation to be all bad news, but I just want to make sure you understand what you're doing when you file a declaration. The law says that users are allowed to file a sworn statement and declare their water rights on file with the state engineer. The state engineer more recently in the last couple of decades started taking the position that it gets to kind of determine the accuracy of your declaration at that stage. That didn't used to happen. You used to go in and just do a sworn statement. It was like prima facie evidence. Here's my evidence, and they could rebut it later, right? That's what the law allowed you to do. It was like an affidavit. Now the state engineer says, no, we don't, I know you're swearing to that, but we have other evidence and we don't agree with you. And they'll reject your declaration. And your only recourse when you get a declaration rejected these days is to take it to hearing. And it's expensive. And you're kind of caught in a process that I don't think you even realized you were getting involved in. And so a lot of folks don't file declarations because they don't want the hassle. And like I said before, you're not required to do it. But if the state engineer were to start active water resource management in this valley, you're kind of going to be faced with, can I prove up my water rights? I'm going to have to do that eventually to get in line into the hopper on where I am with my priority date and what my water right is. Once the state engineer determines water rights, and actually as a practical matter, if the MRGCD still continues giving everybody surface water the same, no matter what your priority is, that may protect you in that event. But I do feel like if priority administration starts happening in this valley, there's going to be a lot of legal challenges, even to the MRGCD's policy. Because really what's happened over time is people with pre-1907s have sold them to cities. And then the folks that haven't say, that's not fair. Why do they get to use MRGCD water and I've kept my water right? And you're treating us all equally. That's the tension that happens with irrigators in the Middle Valley. So in any event, if the state engineer exercises authority to administer priorities in this valley, figures out a list of administrable water rights and then says, I'm going to cut everybody off at 1972 because we need to get water down the river to Texas for the Rio Grande Compact. And if we don't cut off these users, we're not going to have that water in the river. I'm making this all up. Okay. This is like in the future. But that's what the Active Water Resource Management Authority allows the state engineer to do. And your only recourse under these current versions of regulations to challenge that determination is to go to court, to go to litigation. You get deprived first and have to go to court later. You don't have a pre-deprivation hearing process. So again, not to just give a lot of bad news, but that the state engineer does have that current authority right now. The other thing, the AWRM statute and regulation, well, the statute doesn't, the regulations allow is shortage sharing agreements. So the alternative to strict priority could be for users to get together and say, state engineer, we don't want strict priority. That's going to cut off people that we don't want to be cut off. There are junior users that are really important to us, right? Cities are really important to us, and drinking water in cities it's important. We don't want you to cut it off. So we're going to find a way to somehow share shortages. And we want to provide a softer landing for all the water users than this harsh stick of priority administration. Shortage sharing agreements and all sorts of alternative administration plans are all over this state. And like I said, New Mexico's, we have a priority administration law, but we have a cultural history tradition of sharing. And so we get really creative with how we share. And that's a good thing, but unless the sticks there and the dangers there, people don't usually want to share. So there's kind of some motivation to get those agreements going. Okay. And one thing I wanted to say about the AWRM and priority administration, if you happen to be a junior and there is an order that you have to shut off, the only way you can really continue using water is if you find replacement water. You find replacement senior water. So you're going to be out on the market looking for somebody who will sell you some water to allow you to continue using your junior water. So that's the way it works. And so when we talk about replacement water, it's so that you can keep using in priority whatever use you have. So why is this important finally? Through time, senior water rights in Corrales have been mistakenly eroded. This is something that I started noticing 20 years ago. I've lived here 25 years. Just through the people who come through my door. And I used to do a lot of water work in Corrales, but now don't get the pleasure of doing it because I'm so busy with others. But I used to do a lot of different little projects for folks in Corrales. And I started noticing, oh my goodness, you used to have pre-1907s here, but there's been a house here for 40 years. You know, the old maps show it. There's been a house here for 40 years and there's no transfers and it's gone. The building of homes on old irrigated property, the building of roads, improvements. The other thing that unfortunately I see all the time is the erasing of pre-basin and vested groundwater rights by obtaining new domestic permits. And you'd think, well, who would do that? People who just don't know. There are a lot of properties in this area that had old wells, that old homes, old farm properties. They used them for irrigation. They used them for their domestic uses. The well breaks, you know, after 40 or 50 years, the well's out or the water level's too low and they need to go deeper. And they go to the state engineer and they say, I need a new well. And the state engineer goes, here you go. And they hand them a 72-12-1 application, pay your $100 and you get that permit and go drill your new well. Easy. That's so easy. And they never say, oh, do you have an old well on your property? Do you know that you have to do a different process to preserve your water rights in that old well? And that unfortunately has happened a lot in this village. And it's a mistake. And it's just people not understanding that if they have an established pre-basin or old permitted water right, the state engineer records are much better now. So sometimes the state engineer will see you and say, oh, you have a point of diversion. We see a permit on your old property. Fact, my property is not of record with the state engineer. There's no point of diversion record on my well on my property. So not every well is of record with the state engineer. The older wells don't appear. No one's declared them. They're just there. And so sometimes if they see you have an old well, they'll say, hey, let's check this out. You don't want to waive your water right. To do something new with that established water right requires an application to the state engineer, publication, some time has to pass. It's more of a hassle. It just takes more time. And so people are usually very happy to get a new permit thinking, I don't care, I just need a well. I just need that today. That could actually erase a water right that was established for uses with a senior priority date. Let me give you an example also, Melanie. Really hard to see because the 1935 aerial is in black and white. But this is the same area in Corrales. Like in the color one in the middle where the road is, if you see kind of a brown area right in the middle to the left, that's right by Old Church Road. This is what that area looked like in 1935, and that's what it looks like today. And I can tell you, just through my work in the village, not all those places that are not irrigable anymore transferred their water rights for other uses. And just over time, the eroding of abandonment under roads improvements has had an effect in Corrales. And you can't just go back and say, I'm going to resurrect those water rights. That's not going to be allowed under the law. Now, there are some creative ideas I'll share with you at the end of some ideas that we've thought about. I've talked to Mike about, and I talked to the prior village administration years ago that never really got legs. And I don't really know if they really have it will have legs, but there's some things that possibly we could try to do in Corrales to argue that some of those rights haven't been lost. So next slide. So again, I don't want to be Sally Sadsack, but senior water rights erosion threatens our agrarian culture here and our future water security for all of our needs. Yet it does threaten our irrigation and rural needs, but it also threatens our ability to have a water supply for other needs in the village. And for whatever direction this village wants to grow, the thing that Corrales is very unique because we are down by the river, right? We settled by the river because it was easy to use the water by the river. The further you go, it's harder. So we're down by the river, and we don't have a municipal water supply. So we don't have some big thing out there, water provider that has money to go buy water rights for us. So we don't have this supplier that has pre-1907 secure water supply for us. We all have little individual wells. And because we're close to the river, when we pump those wells, we impact the river. So when you're a junior impacting the river, that's not good for New Mexico's depletion needs and for meeting compact requirements. So we're vulnerable. If we're junior users and we're close to the river, we're just vulnerable, all of us, right? And that's why this issue is very important to me, because I want my community to have the best chance at surviving shortage administration in the future, in what the future brings. So next, Melanie. So other current challenges that we have heard a lot about recently is Corrales is currently not receiving a reliable surface water supply from MRGCD or delivery because of the problems with the Corrales siphon. I know that Mike and I failed to mention that we're on the board of directors for the Corrales Farmers Cooperative. So we have been, all of us in the community, and lots of folks and legislators and representatives and are all working really hard to try and get the siphon solution, a resolution to that. I will say, for those of you that don't know much about it, the issue now is one between the Pueblo and MRGCD in finding permission to go on Pueblo lands and repair or replace the siphon. There's a dispute as to whether or not MRGCD ever had the legal right. But regardless, MRGCD, I don't think wants to fight about that. And they've been trying to negotiate with the Pueblo with a solution. And there's money to do it. There's money to do the project, but two things are happening. The money deadline is going to be coming up. And in New Mexico, if you don't spend the money, it reverts. Like water, if you don't use your water, it reverts. So we're going to try really hard to beg and plead that appropriation be renewed and kept in place. I think the Water Trust Board has a meeting in April, I heard, where that's going to be on the agenda. And I hope a bunch of us can reach out and try and encourage that. I spoke with MRGCD's legal counsel today, and he gave me an update on the negotiations with the Pueblo. And all he could tell me is it's not likely to resolve for this irrigation season. Regardless if it did resolve, they would not be able to get the project done by this irrigation season. So I did learn, though, that they did buy an additional pump. So there'll be 3 pumps instead of 2. The problem is, though, that the pumps can only really be operated if the levels in the river are high enough. So also, I understood the MRGCD's chief engineer will be here at the end of February, I think at the village council meeting at the end of February to give a report. But I know a lot of people are working really hard and they understand what's going on in Corrales right now for the farmers, but it's not looking great, because I don't think river flows are predicted to be that high early irrigation season. So we are trying really hard to get state engineer attention, and I hope that some emergency wells or something can come in and we can come up with a plan or something for those that really need this for their farms. So one other thing that I just learned, and this is just an item of interest, somehow the Army Corps of Engineers determined that the Corrales Madre, the Acequia Madre, the main Corrales, is a water of the United States. Did you hear this?
Yes.
I just heard this.
Ridiculous, but it's true.
It's ridiculous, but it's true. And I guess MRGCD is fighting this. And one bright light from the siphon problem is that because we're having to cycle between the 3 different delivery structures in Corrales every 3 weeks, you either get the Corrales, Acequia, Sandoval, is that it's intermittent water. And so it helps on the Army Corps of Engineers argument. But yeah, it's sometimes what's going on is just unbelievable. But the other challenge that we have is that domestic wells cannot be used to irrigate more than 1 acre or for commercial irrigation. I am just telling you that this is the law. A lot of folks understandably may be turning to domestic wells or wells permitted under the domestic statute, but legally, the state engineer, if they get wind of using a domestic well for commercial irrigation, will give you a notice to shut down. I've personally been involved in a few of these cases in Corrales recently. And Google Earth now shows greenhouses really clearly, and people using domestic wells for commercial greenhouses is an issue being enforced by the state engineer right now. In order to keep using that well, you need to acquire water rights and transfer it into the well that would allow you to use it for commercial uses. So that's going on as well. There's been a moratorium on supplemental irrigation wells for 2 decades-ish. They used to allow you, if you were irrigating under the MRGCD permit, to go and get a supplemental irrigation well to supplement supply in times of shortage, which would help a lot of folks right now if you could afford to drill a well. That's been in place for a very long time, and that is a place that I think we could possibly approach the state engineer and beg for emergency approvals as supplemental wells. This requires cooperation of the agency. So I just want to say that. And then transfers of pre-1907 water rights or any sort of vested water right that you could transfer into a well, it's not easy. It has a high transaction cost in time. And if you use lawyers or if you get in a fight with the state engineer, you're paying people to fight with the state engineer, right, Rick? So, I mean, some of you guys have had these issues, and I've worked for some of you guys. So, the bad thing is that your only recourse to fight a negative state engineer decision is to go to hearing. And then that's another timely, costly process. So what are our options for rectifying some of this history and challenges? I think that fixing priority and permitting mistakes could happen if we had the cooperation of the state engineer. And for example, the example I gave you about somebody waiving an old well and getting a new permit, a 72-12-1, I think we could do mea culpa. Mistakes are not intent. And I would argue that under the law for anybody. And I've argued that for some people, and we've settled. So mistakes, I do not believe rise to the level of intent. And so it possibly we could approach the engineer and say, hey, look, clearly this had an old well. They didn't mean to abandon their priority date, but they did get a new well. They're still using water. They didn't abandon use. Can we allow them to file an application to preserve that priority date? It's a transaction, but if it's important enough and it has enough quantity and a good enough priority, it might be worth it. So that's one thing. And then that kind of unified effort would be more efficient than doing these piecemeal case-by-case cases that I've been doing, because you get inconsistent results. There's no real policy. It's very costly for individual users. And so anyway, Mike and I have talked about that, and it's one of my wish list items, bucket list items, that never really has come to fruition because there hasn't been a lot of like push. But I think what's going on right now in the village may help give that push. And then what can be done to prevent priority erosion in the future? You being here is one thing. Getting educated about what to look for before you just go get a new domestic well permit or before you construct something on irrigated lands, figuring out what you have and helping your neighbors figure out what they have. Going to the state engineer and starting to look and see what you have. One other idea I've had is in Santa Fe, to get a domestic well, you have to get a permit from the city. And then you go take that permit to the state engineer. It's an ordinance, and the law allows cities to pass ordinances saying you need a permit from the city to get your domestic well from the state engineer. One thing I always thought would be helpful for Corrales is require like a really minimum fee, like $5, $10, or whatever, to get a domestic well permit. And then when you get your permit, you get a fact sheet. Have you determined whether or not you have an old well? Some sort of fact sheet that comes with your permit that says, beware what you're doing. Make sure you're not just going and getting an automatic domestic well. It's an education idea. I don't want it to be onerous for people to get domestic wells. That's not the purpose, but I do feel like the village as a whole would benefit from us all understanding what we're doing. Okay, next, Melanie. And then finally, if there was some sort of priority administration, we'll all be faced with finding quick ways to acquire senior water for replacement. And existing mechanisms are, we have a leasing statute in New Mexico that allows this to happen. It's currently being proposed, regulations are being proposed to revise that. But it was a quicker way to get automatic approval to lease water, subject to a final permit being issued by the state engineer. For irrigation uses, there's the MRGCD's water bank. If you sell water or you buy a property that has no water rights, that has severed water rights on it, you can go to the MRGCD and apply for a water bank. As long as water's available, they'll let you use it, but it's subject to availability. They'll also shut you off mid-season if there's not water available. And then some potential new mechanisms that over the years I've brainstormed, and this is the area I was saying that what could you do about that aerial, proof of all the stuff that's come in that used to be irrigated. Sovereigns under the law can't abandon water or can't abandon property rights because they're sovereign. And I've always thought it would be a creative argument to argue that at least on roads and that are owned by the village or properties that are owned by the village, if we could somehow do research to see if there were old 1907 rights on those and go to the state engineer and say, hey, these haven't been abandoned. They couldn't be under the law. Let us create a water bank And the village could lease that water to folks in times of shortage or for anything. You could offer it to the public for lease. And these are creative ideas that I don't know if they'll fly, but I do feel, and this was the same idea I had in 2016. So that many years have passed already. The state's going to have a little bit of a hiccup because they'll see it maybe as a new depletion, but I doubt there's going to be that much that we could resurrect. And then Mike's going to talk to you about some other stuff that he's working on in line with this. So final slide. I just wanted to say thank you again for coming and getting educated about these issues. I do think it does take a village to help us provide ourselves a secure water supply. And that picture of the kids was, I think, from 2013 when I was on farmland preservation. And that was at the Gonzalez field. And the kids were there for a seed harvesting workshop. And, that's who I hope we're doing this for, is to make sure that our community can thrive. Thank you. Oh, questions too, I think Mike and I, or do you want to take them after Mike or?
Well, just to process for the audience, I mean, we're happy to take some
Yeah.
questions now on specifics that you heard from Tessa, and then I'm going to talk about more of the wet water side of things on what we can plan for here in the near future. But if there's a few questions that you'd like to address to Tessa, then we can go there.
Just come up to the microphone, please, so that we catch you on the Zoom recording.
That was very informative. So I hope I'm hearing this right. So if we wanted to pursue something like Santa Fe has, would it have to go, would it have to go through our planning and zoning, or after we, the ordinance would have to go through planning and zoning, but would they know where the old wells are, or would we have to go through the state to find out about old wells?
My suggestion wasn't really for the village to determine anything about people's wells. It was more that if somebody needs to drill a well in the village, a new well, that the village have an ordinance that requires them to come get a permit first from the village to do that.
Okay.
And this is under the domestic well statute. There's a state statute that says domestic wells will be, regulated by the state engineer, but if a municipality wants to further regulate them, the municipality can pass an ordinance. And that's why, I don't want Corrales telling you whether or not you can or can't have a domestic well, but it would be a process by which the user, the resident would go to the village and say, I'm going to replace my domestic well, or I need a new domestic well. And the village would go, okay, well, give us $10 so we know you're going to drill that well. It's like I don't know what the specifics would be, but the purpose would be that when you get your permit, you also get a fact sheet.
Right.
And so really it's more of a public service permit. That's my idea.
And so that would be for all new construction, not for people.
Even if you are having to get a new permit for your well that just broke.
Okay.
That's actually more important because then you're in a position where you need to research your old well's status.
Correct.
So that would really help open people's eyes.
Yeah.
Okay, thank you.
Yeah. It would be more of a public service than an onerous requirement, if that makes sense.
Right.
Yeah.
It sounded like it would be a public service.
Yeah.
And incidentally, I'm familiar with the Santa Fe ordinance because I was part of it when I worked for the city of Santa Fe. And one of the reasons they passed that ordinance was they didn't want people drilling domestic wells if they were within 100 feet of the municipality system. So there's a lot of different moving parts to these things, but that's another reason.
You could have strings attached. That's the way most municipalities use that power, but I would hope that we would do it as a public service.
Sure.
Yes, I haven't gotten one of these notices for a long time, but every once in a while, you go out to the mailbox and there'd be a flyer pasted on, taped to your mailbox. And it was always some water broker guy and a water bank
Who that
involved.
was.
And what the heck's a water bank?
It is, okay. there is a company called Water Bank. And then there are water banks that are, is a generic term for a system of users deciding that they want to create a consolidated resource of water rights available to lease and use to others. Acequias do water banks. Acequias can do, they're like water conservation plans. And acequias can come up with a water bank plan or a conservation plan and say, hey, members, we understand some of you, let's say, are working a lot out of town and you have contracts that are going to have you out of town for 2 years. There's a process by which you can bank your water rights with us and we'll let others use them. And under the law, it provides a protection from non-use. So there are legal ways you can bank water rights and then let others use them to protect them from non-use. So that's a generic use of the term water bank. There is a company that's been around for a very long time by Bill Turner is the main owner. I think he used to be the natural resources trustee for the state of New Mexico. Been in the water broker business for a very long time and does actively hoof, I would say ambulance chase if he was a lawyer, but he's not. He's a water boat chaser. He looks at research and he looks at people who may have water rights that haven't sold and transferred them. And he does research and he goes and knocks on their door. I'm betting that's the water bank company that you've been contacted by.
You were talking about that Acequia Madre, but I didn't understand what that meant.
That's the main Corrales acequia. Sorry.
I know where it's at. I just didn't know
Yeah.
what it was.
In the old Corrales days, I think the acequia madre was there since it didn't look the way it looks now,
Right.
but original in the 1600s. I think there's some evidence of uses. So acequia madre is really just the mother ditch.
The mother ditch.
And when the MRGCD came through, in some areas, all the old acequias were preserved. Some people didn't want the MRGCD telling them what to do with their acequias, so they have some joint kind of don't they still have those joint agreements in the, yeah. But yeah, so it's the Corrales main ditch or the Corrales, I sometimes call acequia madre.
But it's recognized from the 1600s.
I think so. I know that there's some records that the ditch, not the full length or where, but I believe there are some historic records. I actually live right on it.
Okay.
So
Okay. Second question was, if I have an old well and I need it to be punched deeper, then I still go through the company, through the well company also. And then he doesn't have to get a permit anymore because I already have that old well.
there's an application to repair and deepen.
Repair and deepen.
Yeah.
That's what I was looking
And
for.
generally, those don't require any sort of additional administrative procedure. You just need to tell the state engineer you're doing that. And generally, they grant the right to do a permit to repair and deepen.
And there's the high probability that you can't increase the production of that well
Sure.
because of that unless you have acquired additional rights that go with that. So
Well,
They
when I-
limit the well to its original capacity, but you can repair and deepen.
yeah.
Okay.
We
Okay.
can't increase casing size.
Yeah,
or-
it would just be the same size
Mhm.
casing. Because I was told not to ever abandon that well from the state engineer at that point.
Mhm.
Okay, one more question for you. Hang on here, because now I don't remember, but it's terrible writing, but okay, I figured out.
Maybe after Mike, you can ask after.
Yeah. I guess we could pull up my presentation. Oh, go ahead.
Yeah. If I may.
Please.
Okay, thank you. Just a couple things. Thank you. When you were talking about permits for the village and stuff, it caught my attention. Has there been any sort of educational push? There's very few well drillers out there, and contacting them before they go to a citizen's house, trying to educate them
See, and they're part of the problem, Anthony. So very good. A lot of times people call, I won't even give names, but well driller, and they'll say, oh, I need a new well. And the driller will go, I'll get a permit for you.
Okay. Yeah.
Yeah, and that's fine. They're providing a service. But you need to tell the driller, well, wait, I don't know what kind of permit I need, but the drillers often are the ones saying, oh, it's easy. I'll just go get you a domestic permit.
Right.
So yeah.
And I've seen some of these residents where they've come to us because their well is dry and we try to provide them some water, non-domestic,
Mhm,
from the fire station for their
Mhm.
animals and stuff until they get their well drilled, but it's usually an emergency.
mhm,
So they're kind of caught in that gray area. But one of the things is there anything that specifies, when you said if you don't use it, you lose it, but does this specify how much you have to use?
Well, it's difficult for the state engineer to determine how much you're using if you're not metered, unless it's an irrigation right and they can see how much you're irrigating. And then they can possibly see what kind of crop you're irrigating. The thing that's changed so much in the last few years is Google Earth. And now we have something called Real ET. Have you seen that?
Yeah.
It's a fascinating tool for people like me that get geeky about this, but NASA has a public online tool called Real ET that you can go on, and it takes remote sensing data from satellite images, and it measures the heat and the evapotranspiration occurring on a field. And it's really cool because we used to pay experts tens and thousands of dollars to look at those aerial photos for clients, but now it's free, but it's also available to everybody.
Yeah. Okay.
And you can find, if you get on Real ET, you can go and look at your property and you can go see what these satellite images think you're using on your property. It's not 100% accurate, but it's a lot of information. So with that caveat, if you're using water for commercial purposes for an indoor use or something and you're not metered, that's going to be hard to create a record of non-use. Once you get a permit and there is a metering requirement and you have to tell the state engineer what you're using, that creates a record of non-use. Generally, I tell my clients, I never want to tell a client to waste water to preserve a water right. But if you don't have the need for it and you used to use it, do something with it. Give it to somebody, or not give it, sell it, do whatever you need to do to somebody else. But sitting on it, you're going to
Put it
lose
in
it.
a water bank,
Put it in a water bank.
Yeah.
Yeah. To preserve it. Yeah.
the Corrales Water Bank.
Yeah.
I guess the last thing too is, obviously you guys know who I am. I'm the closest thing right now in the village to like a water department, but we're talking non-domestic water use, fire suppression. So you see the tanks. We've gone through the process where we have the RG wells. We've gone through, have a point of diversion. So we have allocated water rights. I don't know all the details. You guys would know better than I do, but we have water rights are allocated for off-site water use for fire suppression. We have determined that, some of those water rights, we sell water for non-domestic type use. And you guys see the water lines going through. So it's a conversation, especially now that we don't have enough water going through the acequias of, hey, chief, can we hook up to your water line for irrigation? And so that's a conversation that people are asking a lot about because the water line's getting closer and closer to their houses or their farmland. In your experiences, and I know you don't represent the village, but is there other similar communities throughout the state of New Mexico with your experience that are kind of in a situation where I am as far as providing water strictly for non-potable water for fire suppression and building the infrastructure as we go to maybe help me seek funding, whether it's local, state, well, maybe not local, state, federal, to help me or the village with this type of need? Because
Yeah. Anthony, to answer your question is really easy. Probably there is that kind of funding available, but what's more determinative of what the village can do with that water is what its water permits say it can do. And if you don't have an irrigation use, purpose of use in your permits, no.
Yeah.
Because you can't use your water in contrary to your permits. So that's a limitation. And if the village wanted to be able to do that, it would need to apply for that purpose of use for that water right. that I'll tell you, just as a very general statement, okay? The state sees, and it's a fact, most of our depletions all across New Mexico arise out of agricultural use. That's just a fact. So when the state sees increased depletions, it wants to reduce outdoor evapotranspiration and ag depletions. You don't get a lot of bang for the buck shutting off somebody's domestic well because we use it for drinking and showering. It goes back to the septic tank and it's a very low consumptive use. So indoor uses aren't really seen as the culprit for depletions in New Mexico. It's outdoor uses.
Yeah.
And so anytime we say, for example, the domestic well regulation, when I was saying the state may take the position it can do whatever it wants with your domestic well, well, the state I've seen draft regulations where the state says in times of shortage, you can't use outdoor water with your domestic well. That's where they go to reduce depletions because that's where it evapotranspirates and it's lost to the hydrologic system. It doesn't go into the ground. So it's unfortunate because all our senior uses were established with agriculture. We all want agriculture to thrive, but it is our highest consumptive use. So when the state wants to reduce consumption, it looks at outdoor uses first. They're the most senior a lot of times, so they can't do anything about it. So it's harder to get the right to use a new irrigation use.
But
And-
with that said, Anthony, you kind of teed up some of the stuff I'm going to bring up in my
Okay.
presentation about opportunities to start.
Yeah, and if I may, I'm not, my whole purpose is public safety, right?
Sure.
So everything we've established has either been funded through fire grants or matching funds through state fire marshals funds, which are strictly for fire suppression.
Sure.
And so we start deviating from that, then I'm kind of out of the picture. And then it has to be taken over by another entity because I can't use some of my fire funds to match that. And I guess that was the
Understood,
question.
yeah.
So it's kind of,
Yeah,
yeah.
sure.
and the other thing I know I'm taking up a lot of time here, but I have personally been accused of, as we build these tanks and we run this infrastructure, citizens have been afraid of me taking away their water right. And I assure them by running a hydrant line and a main strictly for fire suppression, that we have no intent of ever taking anybody's water right away. Have you heard of anything like that?
No, I can tell you though, when I first gave Water Law 101 to Corrales, I think it was in 2004, I had a baby. And I was like, sometimes I think it'd be great to make sure our water is safe drinking water. And sometimes I think it'd be great to have a community system. Oh my goodness. I was chased out of the room with pitchforks and I love my domestic well. I love it. And I love my water rights. But I certainly understand why people, this village has very strong feelings
Yeah.
about retaining individual water rights. And I totally get it. There is also, though, I think the need for some redundancy. We're seeing the need for some redundancy, and Mike is going to talk about that.
Yeah.
I think you can do both. I think the village can have a water supply that helps us with our safety concerns and possibly in some areas of the village provide drinking water because septic infiltration in small lots are like ruining the drinking water. I don't know. I'm not going to chime in on that, but yeah.
Yeah, thank you.
And I'll just say too, because of the municipality status, that it's on, you didn't bring that up.
Yeah.
In your water rights presentation, but municipalities can reserve rights for future use, which is an unusual situation, but depending on what the class of the right is that you've put in the wells and all that kind of stuff, that
Yeah.
it really makes a difference, but.
They have a 40-year planning horizon, so they can hold a water right for 40 years and not use it.
Yeah.
That's what makes water banks run by municipalities a really cool option.
Yeah,
Wow.
yeah. So
Thank you for your time.
You bet.
Can I ask one question before you move on to Mike's presentation? So as village clerk, one of my jobs is to operate and run the village website. So I'm thinking we don't need to wait for an ordinance to create a frequently asked question fact sheet.
Mhm.
Would you be willing to help me create a page on the
Yes.
website
Yeah.
that would be for people that need to drill a well?
But,
Yeah, I would
Okay.
love working with realtors and
yeah,
Okay.
Well
and Main
drillers,
Street.
Okay. No, I think that would be a great
Yeah.
resource for the village to have it on our website.
right?
That was going to be my first question. Why we have to wait to apply for a license, et cetera, to be able to get a fact sheet out to everybody in the community. So thank you, Melody. The second thing is, very quickly, the village has acquired a number of properties in the last couple of years with water rights. If it's determined we're not going to use those water rights, can we deposit them in the water bank?
Yeah, and even transfer them to current points of diversion. Yeah. And then do a 40-year water plan.
Yep.
You know, I mean, it's a great idea for the village to take whatever actions it can to consolidate water rights, get them permitted the way they want them and plan.
Right.
Great idea. Yeah.
Thank you.
I just want to mention, I'm a hydrologist and I was a member of a water committee that was appointed by the past mayor and Ron Curry back in 2018, and we submitted a report to the village in 2020, which we had hoped would be put on the website, but it hasn't
It's not
been.
on there?
No.
I'll
but
go find it and see if
you
we can
can
put it
find
on there.
If you can't find it, I have a copy. But I mean, it would,
I'd love to see it.
Me
one of the
too.
things that
Yeah.
it recommends is that, I mean, we had a sort of a fact sheet for people. If you have a domestic well, you need to be aware of this, both legally and also how to maintain it. If you have a septic system, you need to be aware of this. It's sort of a general sort of fact thing that would help people. And we also addressed the question of whether it made any sense for Corrales to think about putting in a municipal well field and becoming a water supplier. And we unanimously decided it would be a dumb idea and we couldn't possibly afford it. And for a number of other reasons. But some of these questions have been thought about. It wasn't just me. There were three others.
Sorry, what's your name?
Marianne Bashoik.
You are Mary
Yes,
Ann.
yes, we've worked
So
together
I
before.
totally recognized you, but I didn't want to. Yeah. Yeah. Hi.
Hi. I have a mask, you know? Anyway, I just wanted people to be aware that there is something out there and we did look at some of these and, you know, there were 5 of us. The other 3 people were also water professionals. And then we had one member of the public, Wendy, who was kind of kept us all in line. So it's out there and be nice if it was more available to people. 'cause it'd be
Yeah,
useful.
that's great.
Okay.
I think we can tee up my presentation now. And I don't have as many slides as Tessa has. And my job here is to really talk about what's our other, bigger, big challenges that we face here in the village and in the Middle Rio Grande and in relation to the status of the system as a whole, the status of the snowbank, snowpack conditions, and a number of other things. So we can just go ahead and we'll walk this through a little bit. The light colored is the Rio Grande Basin all the way from Colorado down through the El Paso area. This is called the Upper Rio Grande, even though we have upper, middle, and lower in, above El Paso, but this is in the big river. It's the Upper Rio Grande. And there's the Rio Grande Compact, and it really determines the amount of water that must be delivered or can be used by the 3 states associated with the available supply. And it's scaled on an index basis. So, and it's got credit and debit systems built into it. So it's a pretty elegant document. I get questions all the time. Why can't you just renegotiate the Rio Grande Compact? Folks, it's not going to happen. And the reason is that it is a good document. It survived all of the, it was well researched. It was well documented on the hydrologic conditions that must be at, on the upper end of the high flows and the lower end of the low flows. It was calibrated based on, at the time, the amount of irrigation that was going on or could be done, both in Colorado and the Middle Rio Grande, and also the amount of water that was required to be delivered to the lower Rio Grande through the Rio Grande project, that demonstrated the availability of a certain quantity of water that those people had essentially a senior right to because of their development time and history. So that's how it all came about. Colorado delivers at the state line. Our index gauge is north of Santa Fe. It's right by where the Los Alamos Highway crosses the river. It's right below that point near San Ildefonso. That's our index gauge. You ask, well, why don't we measure the water above that? That was negotiated back prior to 1938 when the compact was agreed to, that those depletions above that ODOE gauge to the New Mexico-Colorado border would be locked in at the time of the 1922 conditions at that time. And that's how it's administered above ODOE. All the flows that pass the ODOE gauge are looked at as an index. The average is somewhere around 1 million acre feet. We'll look at that here in a minute. That flows by that gauge, and it's dropping over time. But that's then a certain percentage of that has to be delivered down to Elephant Butte. And we could go on to the next slide just to talk about that. Here's the historic ODOE flow gauge. You see the black line is that average I talked about. And you can see the various drought periods. We had the 50 through 79. We had the really good years of 80 to 99 when Elephant Butte was frequently full and full supply years, as they call it. And then we dropped off into another drought cycle where we're at today, where we've ended up going into significant debit during the drought periods, and I'll show that on the next slide. This shows, you see the zero line is black. The red line is what they call the compact violation line of 200,000 acre feet. That's that credit debit situation I talked about for New Mexico before. But you can see in the 50s, we were in significant violation of the Rio Grande Compact, and then kind of dug ourselves out of it through a number of things, including the development of the San Juan Chama project, I might add, that added another 80 to 90,000 acre feet into the system to help dig things out and also give an alternative non-native supply for municipalities and others to use. But we dug out of debit. We drifted back in just before the early 80s. And then we had a great water years. And you see on the black line, there was three years in a row where it doesn't go above or below. Right after 1985, that's when Elephant Butte spilled each of those 3 years. And they didn't record how much went over Elephant Butte and beyond, but a lot of it did spill out of the lower basin at that time. And then you could see we had credits against the Rio Grande Compact during a number of years. And then we use those credits going into the current debit situation that we have. And I might add that this year we came close to zero on delivery requirements. It was 2,000 acre feet in the negative, but it didn't increase the debit significantly this year. And I think we'll probably see a similar situation this coming year because of the low water supply situation. Next slide, please. Well, before I talk about that, let me talk about Alvaro and the Abiquiu situation up on the Rio Chama. The Bureau of Reclamation is continuing to work through its new contracting and design procedures. They're looking at maybe trying to expedite through some sort of combination of agreements with either MRGCD, possibly the state of New Mexico, to help expedite the construction of the dam, to move it from the federal system into maybe some kind of a partnership agreement. I don't know where that's going to go yet, but they're looking at all kinds of different options to try to expedite the repair of Alvaro Dam. In the meantime, work that was done by a number of entities, led by the Albuquerque Bernalillo County Water Utility Authority, NMRGCD, and others. Working with Senator Heinrich's office, we were able to get in what they call the WRDA bill, which is the Water Resource Development Act, is the fundamental authorization for Corps of Engineers bills and funding and whatnot for water projects throughout the United States. We were able to get in that bill the ability to store native Rio Grande water off the Rio Chama in Abiquiu, in addition to the San Juan Chama that was already authorized. So that gives some flexibility there to address the prior and paramount water rights for the Pueblos, as well as additional agreements that the state engineer could permit for other entities to store there. However, we're still in 125,000 acre feet of debit to the compact. So because of Article 6 and Article 8, other requirements of the compact, it's really difficult to store a lot of water either in Alvaro or Abiquiu without, well, you first have to store the debit before you can have excess water to use within the Middle Rio Grande. So that's kind of the setting from a compact perspective. But the good news is that a project that I've had on my list for, at least 20 years of my career is to get that native storage at Abiquiu, and hopefully in the negotiations and settlement with the 6 Middle Rio Grande Pueblos on their water rights, we can figure out how to get a similar storage opportunity at Cochiti, giving us one more northern reservoir to allow for better management of water, particularly in light of the fact that over time, our snowpack is going to diminish just due to increased temperatures. And I look to you to really investigate that in this particular document, the climate change in New Mexico over the next 50 years. And it's really drills into what we're facing when we look at another 5 to 7 degree temperature increase over the coming decades on what will happen to our natural water supply, primarily from the watersheds and the snowpack. And how do we match that up to our 20th century infrastructure and our policies and water management rules? So those are the things that we're faced with in New Mexico, is how do we chew this up? How do we prepare our communities for a diminished surface water supply in particular from the historic snowpack runoff? I'm saying that we'll probably, this document actually says our precipitation might be fairly similar. And we can go to the next slide on that. You can see temperatures have increased since, say, 1990-ish, 2 or 3 degrees Fahrenheit already, just on the basis of that upper red graph. The lower graph is kind of our average precipitation that bounces all over due to hydrologic conditions, but you can see we're diminished some in recent history, but we think we're going to see at least similar or higher amounts of maybe more summer or monsoonal rain events, and we may see winter rain events like atmospheric rivers at higher temperatures. That's going to require a different kind of infrastructure to capture those kind of events. And so we got to really think about that going forward as another component of preparing New Mexico for a more arid future. And so that's in this document. I would strongly urge you all to take a look at it. It's on the Interstate Stream Commission website. And it's kind of a sobering document, but it's also something that gives you some ideas of what our scientists, our best scientists in New Mexico are saying we're going to face here in the coming decades. Next slide, please. And this is another one in the document, and it really talks about comparing our average temperatures that we've observed to what the models, several models, 20 different ones that they've run continuously and overlap to try to show you how estimated temperature increases are going to change in New Mexico over time. And the northwest part of the state's going to see the highest increase apparently compared to the southeast, because it's already hot down there, folks. Next slide, please. All right, this is really the heart of the conversation that we need to have here in the village in particular. But I think the only way, and it's been the focus of my career, my entire history of being in the public sector water community, is that you got to form the partnerships. You got to develop the relationships with Middle Rio Grande Conservancy District, because they obviously are in charge of all the infrastructure that gets our water to all of our head gates in Corrales. They do not have a role to play on all of our private ditches and other options there. And that's something I want to talk about a little bit. And take a look at, how do we improve water operations, the issue of the siphon, they're adding another pump, but you also got to keep in mind, we've got endangered species issues that requires a certain amount of flows to go continue in the river. And it's not, what's great about the current biological opinion is it doesn't have target flows, but there's operational goals of maintaining a certain base population of the endangered species that requires, fish need water, right? So there's that piece that we always got to keep in mind. We can't just dry up the river at Corrales with a new check structure, right, and pull it all in with a pumping station. So there's that piece. And MRGCD has some pre-1907 water rights that may be associated with their works here in the village. So there's some things we can look at there. Obviously, the Office of State Engineer, as Tessa has talked about a lot, is critical for us to have a really good working relationship and a partnership to take a look at this very question about how can we put together a water bank? How can we demonstrate to the state engineer that we've lost some historic water rights that should be continue to be reinvested back into the village for not increasing depletions, but holding ground while we're seeing reductions in overall water supplies. And we need flexible systems with some groundwater opportunities that Anthony is working on, and how can we use infrastructure systems to improve our community ditches that make them more efficient. That's the kind of partnerships we want to work with here with the village, with the farmers groups, with the new one we've just formed. And I'd also think we should form a Corrales Acequia Association too, and we need to work on that just to have another voice in the mix. But those are going to be really important, and the village is going to play a key role in that, and within their authorities and abilities to pull folks together and maybe be cost share partners, maybe help us with grant administration, things along those kind of lines. I was able to develop a grant application. It's not even an application, it's just a statement of need within a request for Upper Rio Grande funds that were remaining in the IRA funding for the Rio Grande Basin. Lots of money went to the Colorado River Basin. There was some reserved for the Rio Grande Basin. Not a lot of focus. Some has been dedicated for the lower Rio Grande issues down in the Las Cruces area to help deal with a settlement potential down there. And some of the things they're looking at there is taking more active infrastructure capture and recharge of surface water rain events that right now flood control facilities just rush it down to the river. We need to take a look at that kind of stuff even in the Middle Rio Grande. But I was able to put in a request with the guidance of the Middle Rio Grande Conservancy District as the formal administrator for that request $500,000 IRA grant that the Trump administration is now reviewing. And if we get through that review process and they get that allocation, that grant was designed to do exactly what Tessa is talking about, of researching the water rights situation to see what sort of opportunities and options and work that we can pull together in a document to take to the state engineer to say, hey, we want a pilot project here in Corrales to take a look at how can we move to a more conjunctive use strategy that will keep agriculture alive, but it won't increase depletions. It'll give the state engineer some opportunities to maybe optimize surface water for deliveries when the state needs it for compact delivery purposes, while irrigation can continue with this dual system of operational management with groundwater and surface water. And also do some planning, design, and review of our antiquated ditch system in Corrales that's non-MRGCD. And the district has committed to help us manage that grant. They would be the recipient of the grant and they would manage it on behalf of the Corrales area. And they would also be able to have some cost share contribution with engineering services and surveying and stuff like that. So that's one component that's a building block for us to start to move in the direction that Tessa and I would really believe is the only real future that we have, to be able to build this partnership and work with our local communities, both for our drinking water and our surface water. And I agree, I think we have a real shallow groundwater contamination problem that has to be addressed at some point too. So maybe there's all these different combinations of things that we can put in place that will position Corrales to be in a sustainable water future, both for agriculture, our cultural values, and the needs for our growing community for drinking water, clean drinking water for the future. So that's my pitch. And we're here to continue to answer any questions that you might have.
And I wanted just to say, because Mike and I both use a lot of jargon, because we're just used to talking about this all the time. But conjunctive use means surface water, groundwater together. So just more flexibility in being able to use surface water, groundwater, with some planning about what the effects of that would be. And it's kind of, conjunctive use is kind of a redundancy plan. I always think of it that way too. Because surface water is renewable, and it used to be renewable a lot more. But people went to groundwater when it's almost like the bank account. It's like your storage account that you only draw on if you don't have something in the checking account. You don't want to draw too much on your savings, but it's important that when you need it, it's there. And there are ways to come up with operation plans and systems where you can conjunctively use water in a more efficient way. And I think that's what Mike's talking about. And then one other thing you brought up, Mike, that I failed to bring up is there is now interest in negotiating with the Middle Six Pueblos on their water rights claims. And there has been a negotiation team put together of state and federal representatives and the Pueblos themselves. And so that is kickstarting. And the idea is after that process, if it's successful, resolves, there'll be a way to quantify those claims and understand them and understand how they are going to work with New Mexico's compact requirements, and hopefully come up with some new water supplies, some additional water in basin as a result of those settlement negotiations. And usually those Indian water rate settlements bring in a lot of money to build infrastructure projects. And that's just the way they've historically gone. But it is for some people very, very scary because they're not at the table. Some of my clients are scared. My family's scared because they're not participating at the table, but the major water users, the city, Rio Rancho, MRGCD, the state, of course, and the Pueblos, I think. Is that pretty much who's at the table?
Yeah.
We'll do the first round of negotiations and we'll see where that gets everybody. And then it would, the plan is to have a court enter a decree of some sort where other users get to see it and chime in. So that is happening. Whether it succeeds and when it would is all everybody's guess, I guess, at this point. But it is going.
I asked a question about that, Tessa.
Yeah.
Why is there any concern? The fact is that the prior and Paramount has been determined for decades. We've always agreed upon 9,900 and some odd feet, acres. So how can the Native Americans try to change that on us? Having said that, some of us think that they're changing on us in relation to the siphon, that if we've been there since 1930 some odd, why now don't we have that same easement? Is that the type of situation that we're walking into, or can you enlighten me with something else?
There's a lot so let me back up for a second. On Indian water rights and the way the law looks at Indian water rights, if you are on a reservation land, if there's any sort of federal reservation that reserve lands for tribes, the law is pretty clear on what law applies and how those water rights are quantified. That's under the Winters Doctrine. And for years, we've had case law and folks have been able to quantify and determine reservation land Indian water rights. The Pueblos in New Mexico are very unique history, very unique on every Pueblo has their own history, and how the Pueblo Land Claims Act and all of those things sorted out for different Pueblos is very different history than the general reservation type law across the United States. There are a lot of questions on how to quantify Pueblo water rights. They're not answered. They're pending in courts right now. So although there may have been some assumptions by MRGCD and others on what the middle six Pueblos are entitled to, there are a lot of unanswered questions on what their claims would actually be if they got into court and made those claims. And, we could look at surface water, but future groundwater development and their future needs. There's a lot of things that are untested in New Mexico. And I think this is the first time that the state and the Pueblos see an opportunity to settle instead of litigate. And there are some areas in the state that are still being litigated. I think the Boozleman adjudication with the Jemez, they're fighting this issue right now on what is the proper method to quantify Aboriginal claims, Pueblo claims. So it's not quite a settled issue in the law. And I think more current administrations have felt like this is an opportunity to not risk litigation and try and find a way to bring in additional sources of water and get things quantified. I will say, the future is going to be different. There'll be probably a different market to go to buy water rights and use water rights. So, you may have additional supplies come in and different folks are controlling those supplies, and that provides a place to go get that water, and it's going to be the Pueblos potentially. So, yeah.
Yep. And I'll just say, I've been involved in a lot of Indian water rights settlements from two different vantage points, federal side and the state side. And there's lots of components to them that are not just cut and dried by the current statute, the acts of 28 and 35 kind of define at the beginning of the kind of in trade, if you will, for the easements that MRGCD needed to build everything. One of the things that were established as part of all that were the paramount water rights, as you mentioned. There's also the newly reclaimed lands that I think the Pueblos could argue might have a different status as part of their strategy. I don't know. But they also have other domestic and livestock and tributary claims up on their historic lands that would come into play that are outside of the statutory water that has been identified for their irrigated lands within the Middle Valley. So there's a lot to it.
I know there are legal arguments on both sides, I guess, is what you can say is that different parties are going to point to different areas of the law.
Right.
And whether or not you want to go to court and litigate those or try and settle them, I think is the question right now. And at least the past administration on the federal side supported this. Then they assigned a negotiation team. But who knows what the future brings?
Right.
Hopefully there'll be an opportunity, and there will be. There's no way to get a court decree without giving notice to all water users. So hopefully there'll be an opportunity for folks who have concerns to chime in on the process at some point.
Yeah.
We have 10 minutes because we have a hard stop, right, Melanie?
Yes.
At 7:30.
7:30.
This is more of a question about, so we're in the process of looking at our vegetation management plan, right? And so every time we do a project, we're always looking at, vegetation, and I hear it all the time that, some of these elm, salt cedar, things that I believe we can, do a better job managing. However, some of the mature elms are our only shade trees that we have, or we may have, because some of the cottonwoods are dying. Is there anything out there that we can use as we develop our vegetation management plan that will give us information that we can give to the public about, if you have a field full of elms, it might be in the best interest to get rid of those because of the water use? Have you seen anything like that we can use to try to determine? Because water conservation is a key thing here. And if we can, I'm not saying clear cut everything, but if we could do better in our vegetation management plan to help offset some of the water suckers, I guess I would say.
I don't know. Do you know the relative water use of an elm versus a cottonwood? Does anybody? I know they're non-native. Oh, it's in your report?
And it kind of, you did do an assessment there of vegetation and recommendations for vegetation.
Okay.
And things to tell the public about how to save water and how to deal with vegetation. I mean, it's a start, and the advantage of this report we did is mainly there's a whole list of references and places to go to find answers to those kinds of questions.
Okay.
So I think
And the climate document gets into that somewhat too.
Yeah. Okay. Well, thank you so much for that. And I'm actually kind of embarrassed. I don't know about all that detail. So we will definitely look at that. And yeah, so thank you. And one more question pertaining to retention of water, like on private property. So I know our zoning, we try to encourage property owners to retain, some sort of pond on their property, and our code enforcement officers usually trying to enforce that. So what about gray water use? Is that something that we can maybe look at more providing to the citizens about using gray water for water conservation as well?
I've been a student of that a little bit, just in my, not in my formal career under the Water Rights Administration side. That's more kind of a environment department issue.
Okay.
They do have some regulations in place. I think that there has to be clear separation from the black water and the gray water and all this kind of stuff that goes on there. There are actually Colorado has done a lot of work on that issue about how much is allowed to be used both off of roof capture and also gray water. Where before it was like they needed a permit and do all this, but then they've come up with more relaxed, I guess, approaches to it, as long as you're not, and it kind of depends you know, a lot about the development itself and,
Yeah.
you know, because there, you know, a lot of folks are putting in swales to capture runoff and all that to get it to recharge and create water sources for landscaping and stuff like that. Those are all really smart things to do. But there isn't really a formalized permitting process at the state engineer's office for gray water.
Okay.
Separation or anything like that.
There is a state engineer regulation that you cannot impound stormwater for more than 96 hours.
Oh,
You
wow.
cannot have a new pond on your property that impounds water for more than 96 hours. You need a permit from the state engineer for small livestock ponds.
Yeah.
So you cannot just go and dig a pond and store water in it on your property without a permit from the state engineer.
Interesting. Okay. Thank you.
Yep.
Yeah.
And I think we might have somebody on Zoom. Stephanie Baco, did you want to say something? I see your camera's on.
I just wanted to tell Mike and Tessa, thank you for doing this. So great job. I've been listening the whole time. So
Hi, Steph.
Hi.
I think we have 5 minutes if there's any other questions.
So I have a question regarding the declaration. So I went to the state engineer and I did, it's way back in 2009. And I did do the prior to 1907. So we got all that declaration and I went in after your first meeting for the farming here. And I went right away to be sure. But so they certified this, but they won't acknowledge it. The state of engineer won't acknowledge the declaration unless the property is transferred. You know, you sell your property. They said that took place back in 2013. And that's what would trigger the declaration. Now, when you said they would do a priority of analysis, he was able to go back and print me, and I kept them showing screens, Google Earth, basically back to 1917. But this doesn't mean that I actually have.
Yeah, the standard language on the state engineer's letter that comes back with your declaration is it's accepted for filing, but is not to be interpreted as a determination of the water rights being valid. And that's just their caveat language. So, you know, that's standard. And maybe offline, we can talk about, I'm not quite understanding what you're saying with your
Well-
2013 issue.
Well, they changed, I guess, back in 2013. They changed some language and they said they wouldn't do the acknowledgement in the back.
Right, you get a cover letter now that says your declaration's been accepted for filing, and even though it's been accepted, it's not to be viewed as a validity that these water rights are valid or a determination that the water rights are valid.
Okay, so then what would we do?
You just sit still and you wait until a court adjudication and prove up your water rights, or you go to sell them and get a determination from the state engineer of what they'll accept as being valid.
Or try to transfer them into a well or something.
Or
like that.
do something to get a permit. The state engineer will make a validity determination if you change your water right.
If I change my water right?
Yeah.
Because I'm trying to make sure that since we do have this, that we are superior, not junior, if any, you know, and.
There, nobody has that certainty in the entire middle Rio Grande Valley.
Okay.
Sorry.
Okay, well, I wasn't too sure.
But you know what? We still do transactions. And,
Yeah.
And title companies won't give you title insurance, and I won't insure anything that I do for my clients. It's kind of funny. We all have transactions, but we just do what we can in absence of an adjudication. So.
Okay, that's what I was trying to understand.
Yeah.
So how do we get it, you know, so that we could get water?
You have, just keep using your water. Keep
Okay.
using it.
Yep.
Okay. Well, never mind. I answered my own question. Thank you.
Thanks.
Tessa and Mike, thank you so much for your time tonight.
Yeah,
Uh,
it was
we-
a pleasure. Thank you guys for having me.
This meeting will be posted to the Village YouTube site, so if anybody wants to view it later, it will be there.